everyone, and welcome to this Federalist Society virtual event. My name is Marco J. Lloyd, and I'm Assistant Director of Practice Groups with the Federalist Society. Today, we're excited to host a litigation update on Etienne v. Ferguson featuring Matthew Martins. Our moderator today is Hiram Sasser. Hiram is Executive General Counsel for First Liberty Institute, where he oversees First Liberty's litigation and media efforts. His practice focuses on First Amendment and other constitutional and civil rights issues relating to religious liberty. He served as co-counsel in 8 victories before the United States Supreme Court, including Groff v. DeJoy. In addition to his legal duties, he develops, coordinates, and implements successful media strategies on behalf of his clients, including on television, radio, and other mediums. If you'd like to learn more about today's speakers, their full bios can be viewed on our website, fedsoc.org. If you have a question at any point in today's program, please enter it into the Q&A function at the bottom of your Zoom window, and we'll do our best to answer as many as we can. Finally, I'll note that, as always, the Federalist Society takes no position on particular legal or public policy issues, and all expressions of opinion are those of the speakers. With that, Hiram, thank you for joining us today, and the floor is yours.
Hey, thanks, Marco. Thanks for having me. Well, as Marco said, I'm one of the lawyers at First Liberty. And by way of disclosure, I'm also one of the lawyers on the case that we're going to be discussing here. But my role is mostly to carry Matt's suitcase and picking wherever we eat lunch. And also we have, as esteemed co-counsel on the case, folks from the Beckett Fund, and they are great lawyers and have been fantastic to work with. Well, so I'm going to introduce our primary speaker here, Matt Martins. He's a litigation partner at WilmerHale. He's one of the few lawyers, now this is according to him, I mean, I'm just going with what he said here. He's one of the few lawyers who has appeared and won at trial at, quote, all 4 tables: civil plaintiff, civil defendant, criminal prosecution, and criminal defendant. In all, he's tried 26 cases ranging from securities fraud to patent infringement to consumer fraud to murder to employment law, because I always put employment law right after murder, Matt, okay, and money laundering. He's also argued 18 appeals in federal and state appellate courts across the country. Martins joined WilmerHale after a long career of government service, including as Chief Litigation Counsel for the SEC's Division of Enforcement, as Chief of Staff for the Criminal Division at the U.S. Department of Justice during the Bush administration, and as a law clerk to Chief Justice William Rehnquist, and before that, D.C. Circuit Judge David Santel. Matt is also our lead counsel for the Archbishop, bishops, auxiliary bishops, and priests in Washington in this important case regarding the Catholic sacrament of confession. So Matt, before we dive into the case, Etienne versus Ferguson, I'd like just to ask you just real quick about your work in the religious liberty space. How'd you come to be doing like religious liberty cases at WilmerHale?
Well, shortly before I joined, or shortly after I joined WilmerHale, I was introduced to you by one of my law partners. And as I recall, our first case together, you called me at home one night while I was watching Monday Night Football, asking me if I could get a TRO lifted by Wednesday for a religious group to participate in a religious ceremony that Wednesday before sundown. And so I think that was 10 or more years ago.
Oh yeah, that was, listen, if I'm interrupting Monday Night Football, like it's a big deal. Well, that synagogue needed our help, and we had to go. We delivered there, so that was a great win. Now, religious liberty cases at Wilmer, not really a big profit center. I assume you're doing all this pro bono.
Yeah, we do a lot of religious liberty pro bono. I mean, I suspect that we're one of the firms in the country who does the most in this space, largely because of some interest by some other partners and I. And yeah, it's not a profit center. It's not meant to be. It's pro bono work that we are thrilled to participate in.
No, that's fantastic. Before we talk about the specifics of the case, I think one of the things we might want to cover is sort of the central issue of the case is a very old practice known in the Catholic Church as the sacrament of confession. Can you tell us a little bit more about the sacrament of confession and its importance to the faith of your clients?
Yeah, I'll be happy to give it a try. I'm not Roman Catholic myself, but I've learned a lot about this during the case. And so, in short, subsequent to Roman Catholic baptism, as I understand it, Roman Catholics believe that the way you continue to address sin in your life is through confession to a priest, who will then provide you with penance that you need to do, and that's the way that you reestablish forgiveness and right standing with God in the Roman Catholic faith. And again, I apologize in advance to any of our listeners if I'm not getting it exactly correct. And uh, the confession is protected by something called the confessional seal, which dates back, I think there's records of it dating back to the 4th or 5th century. Uh, and it essentially requires that the priest not disclose under any circumstances whatever's learned in the confessional. And over the centuries, priests have suffered martyrdom as a result of their maintenance of the confessional seal. So it's taken very seriously. A violation of the confessional seal results in immediate excommunication for the priest that can only be lifted by the Pope himself. So it's a long-standing practice, both the confession and the protection of the confessional seal in church teaching, and it's taken very seriously.
Now, this isn't the first time a government or a king has tried to uh, uh, break the seal of confession. I mean, from what I understand, I mean, there's been priests that have had to give their lives to protect the seal of confession. So, yeah, obviously, something very, very important to the faith, very central to the faith. Um, so what did the state of Washington do that caused the bishops and priests some concern regarding the sacrament of confession?
Well, it's interesting actually going back to the time when Washington was a territory combined with Oregon, and then when it split off, it had it enshrined in its laws, both during the territorial stage and when it first became a state, a protection for the priest penitent privilege, which would protect not only Roman Catholic confession, but any other faith that likewise recognized a confidentiality around confession or communications with clergy. And that had mostly been the law in the state of Washington, with a brief period of exception in the mid 20th century. And then in May of 2025, the governor signed into law SB 5375, which sought to require uh, priests to become mandatory reporters of child abuse and neglect learned anywhere, including in the confessional, without exception. And without regard to need in the particular case. It was just a mandatory requirement that any clergy, and clergy were singled out by the law, provide a report if they had reason to believe that there had been child abuse or neglect. And so that's obviously a problem. It's inconsistent with church teaching.
Now, it's my understanding that the church was very supportive of the law. What are the parts of the law that the church was supportive of, and what were and what was the main issue that the priests and the bishops had with the law? You know, because it seems like they were supportive of it, but they had the one particular issue. And can you talk a little bit about that distinction?
Yeah, absolutely. The church has had policies that are actually more uh, impose greater requirements on priests to report than the law in Washington had required up through 2025. So the church has taken this very seriously and has imposed its own reporting requirements. And the church was fully supportive of the law to the extent it required priests to report, with the one exception of the confessional, so that they had already been, according to policy, reporting. They were supportive of a law that would require reporting. What they were seeking was a carve out for the one instance in which their faith doesn't allow them to report, which is for information learned solely in the confession.
All right. So on May 29th this year, you and the team at Wilmer Hale and, you know, some folks from First Liberty and the folks from Beckett joined forces to represent Archbishop Etienne and Bishop Tyson, Bishop Daly, and the auxiliary bishops and priests, and filed suit against the governor of Washington, the attorney general of Washington, and for good measure, every county prosecutor in the state of Washington. Why did you sue every county prosecutor in the state of Washington?
Well, because what we have to do is sue the people whose actions can be enjoined in a way that would provide us with relief. So the primary enforcers of this law would be the state and county, or the various county prosecutors, because the statute attaches criminal penalties to the failure to make the report, and the county prosecutors under Washington state law are the ones who have primary authority for bringing those criminal cases. But the governor and the attorney general also have some enforcement authority, some criminal enforcement authority, in a residual basis if a county prosecutor can't or won't bring a case. And so we had to sue the parties that we needed to enjoin in order to provide our clients with relief.
Yeah, I mean, that's pretty common. You did that in Texas years ago as well, on a different case. But so let me ask you. I just want to make sure I understand what was the objective of the lawsuit? What were you trying to achieve with the suit?
So we were asking for a declaration that the statute was unconstitutional as applied to the Roman Catholic sacrament of confession, and an injunction against its application with regard to statements learned solely in the Roman Catholic sacrament of confession. So we were very narrow. We were bringing an as-applied challenge, not a facial challenge, and we were seeking that the statute be enjoined only as applied to Roman Catholic confession, because our clients were solely Roman Catholic.
Okay. Well, so in bringing this lawsuit, what were the arguments you made? I mean, you've alluded to it, in terms of it being um, uh, unconstitutional. What were the arguments that you made in the lawsuit that the law is a violation of the Constitution?
So we brought a number of claims. Our first and primary claim was brought under the Free Exercise Clause of the First Amendment as incorporated by the 14th Amendment against the states. And so the argument was, as your listeners may recall, going back to Employment Division versus Smith, the Supreme Court had said that laws of religion, religious conviction doesn't exempt you from laws of general applicability. But if a law is not generally applicable, or if it is not neutral toward religion, then it's subject to strict scrutiny. And what we had here was a law, we argued, that was neither neutral nor generally applicable. Not neutral because on its face it singled out clergy, and there were statements made by various legislators in the course of adopting the law that it was intended to target Roman Catholic confession. So we argued it wasn't neutral on its face. And we also argued that it wasn't generally applicable. So there's not in Washington State, for an example, a statewide obligation for anyone and everyone who receives credible allegations of child abuse to report. It required only clergy to report. So, for example, you could be standing in your front yard and see your neighbor abuse their child, watch it with your own eyes, you'd have no reporting obligation. But if you heard about it secondhand from somebody in the confessional, you would have an obligation to report. And so the law did not create a generally applicable obligation to report in response to the issue that the state was rightly concerned about. I mean, we're all concerned about child abuse and neglect, but they had not imposed a generally applicable response to that. That was our primary.
Let me ask you. Lawyers, were lawyers mandatory reporters?
So there was carve outs for some lawyers.
Yeah, tell us a little bit about that.
Yeah, so as a general rule, lawyers were not mandatory reporters, but some personnel at universities were mandatory reporters where lawyers may be employed. But then there was a carve out for some lawyers at the universities. And so you had just this, what we called sort of this Swiss cheese effect of some people had to report, and some people at some employers had to report, except those that didn't. And so you just had this patchwork of reporting obligations, and the state had lots of reasons why they thought that that patchwork made sense. And the answer is that that's interesting, but it doesn't change the fact that it's not a law of general applicability. You can bring up your reasons under the strict scrutiny test, claiming you have a compelling interest in narrow tailoring to that interest. But on the question of whether or not it's a generally applicable law, the patchwork of obligations and exemptions made it not generally applicable.
Yeah, there's been a lot of controversy recently about employment division versus Smith. I mean, there's been some Supreme Court cases that have taken some shots at overturning employment division versus Smith. But it always seems that what ends up happening is the Smith just gets narrower and narrower. It doesn't go away, but it's getting thinner and thinner. But this is a case in which there was the argument that employment division versus Smith did not apply at all, and therefore you would go then directly to strict scrutiny. Just so that our listeners, not everybody does religious liberty, might be tuning in. What happens if employment division versus Smith applies? If it's a neutral law of general applicability, what happens? What's the level of analysis after that?
Yeah, so if you're in a situation where the law is not neutral and or not generally applicable and either is sufficient, then you go into strict scrutiny, and the state has to prove that they have a compelling interest and that the law is narrowly tailored to achieve that interest. So if the law is either over or under inclusive, it fails the strict scrutiny test. It's not considered narrowly tailored to that interest. And in this instance, just the example I gave about the neighbor shows you that it's under inclusive. And it's also over inclusive because the law required reporting by priests, even if the information might otherwise be known to the state. There's no need element to it. It's a universal obligation for clergy to report if they learn in the confessional without regard to the state's needs. So the law is both under inclusive, doesn't require the neighbor to report, and over inclusive, it requires priests to report even when the police have other means at their disposal.
And if it is neutral and generally applicable, then rational basis
Rational
applies?
basis review, right? Correct. If it is
Yeah.
neutral and generally applicable, then rational basis review applies. So obviously the generally applicable neutrality question is essentially decisive. Nobody ever survives the strict scrutiny.
But well, yeah, that seems to have been at least the pattern for the at the U.S. Supreme Court, and then also at the courts of appeals almost all of the time. So I want to just kind of break down just a little bit on the free exercise before we move on to another argument. So if the law is not neutral and generally applicable, then you go to strict scrutiny, and who has the burden after that, and what do they have to demonstrate? If you might be able to help us out with that.
Sure. So the plaintiff has to demonstrate that the law imposes some type of burden on their faith, sincerely held religious belief. So they have to show the sincerity of their belief and that the law is compelling them to do something or preventing them from doing something contrary to their religious belief, their sincere religious belief. If that burden is met, and there's rarely challenges to sincerity, particularly when you're talking about a 2 millennia old faith where this is well established in church teaching. In that instance, then the burden shifts to the defendants to satisfy the strict scrutiny, point to a compelling interest that requires, and not just compelling interest generically, but compelling interest in forcing these particular plaintiffs to act contrary to their faith, and then show that the law is narrowly tailored to that compelling interest.
Yeah, Matt, one of the things I teach at the University of Texas there as a kind of a part-time adjunct professor, and one of the ways of framing that question, that compelling interest question, that I like to kind of have them think about is it's not asking what's the government's compelling interest in whatever the rule or regulation is. It's really what's the government's compelling interest in not providing an exception to this person right here in court today. And to frame it, and when you frame it that way, now I didn't invent that framing. Chief Justice Roberts invented that framing in UDV versus Gonzalez, dealing with the Wascatee church thing there, that where they were, you know, drinking the Schedule I substance, drug tea, and yeah, you have a compelling interest in prohibiting Schedule I drugs, but what's the compelling interest in not providing this particular church here an exception, and sort of kind of flipping it in that way. And that was a unanimous decision, 8-0, but Alito didn't participate because he wasn't on the bench yet. But anyway, so so the government has this burden now. They're going to have to show up with compelling interest. What did they show up with?
Well, I mean, they showed up with what you would expect they'd show up with, which is speaking to the state's compelling interest in protecting children. But as you point out, that while we can all agree that's compelling and important, it's not the interest that satisfies the test. Because the question in this instance, under this test, is there compelling interest in making these particular plaintiffs violate the confidential seal? And the state then has to show, if there is, that the law is narrowly tailored to that. And as I said before, this law was both under-inclusive and over-inclusive. Didn't require reporting by everyone who might know about abuse, and required reporting even when there was no need because the state already knew about the case and had proof at their disposal.
Yeah, and it's even narrower than that. I think you know what we started talking about before. It's just the sacrament of confession.
Correct.
And so it's narrow as to the people and narrow as to the practice. And then why do we not have an exception for that? You know, one of the things that I've always I found fascinating, and I don't know if you've sort of encountered this in your practice, and you can tell us if you haven't, you know, what you think about this, but whenever you have an exception that then gets you out of employment division versus Smith and into strict scrutiny, it's like that exception is almost like this train with this special battering ram on it, because it takes you, it plows the field for both getting out of Smith, and then also how can it be compelling if you have exceptions? That's also a lesson from UDV versus Gonzalez. And then that exception thing then drives right into least restrictive means. Now, just so it makes people up to speed on strict scrutiny, the government has the burden of persuasion and proof on both prongs, and you've identified those as compelling interest, and that they're advancing it through that interest through the least restrictive means. You know, who has to win does the government have to win either one of those or both, or how does that work?
Both. So the government has the burden of proof and persuasion on both the existence of a compelling interest and the narrow tailoring. And I think, as I said, and you observed, that state can almost never, and maybe never, win that. The courts have emphasized, both the Supreme Court and the circuit courts, it's a very rigid, stringent test, nearly impossible to meet. And certainly no case in recent memory has survived that. So the fight really does become about whether or not the law is generally applicable and or neutral.
Yeah, and so you know, you had the free exercise claim, and we talked about that. What's another claim that you brought, and tell us a little bit about that?
Well, we developed a claim called what we called the commandeering claim. So the idea behind our commandeering claim is that the state was trying to take control of a compelled speech by the church, compelled confession, and use that compelled speech in a way different than the church had designed it, namely with its confidentiality, to achieve something that the state could not otherwise achieve. In other words, in the criminal context, as we all know, under both the federal Constitution's Fifth Amendment and in this case under the Washington State Constitution, the state can't compel someone to speak about a crime. But the church, through its sacrament and its doctrine, does in fact compel people to confess their sins. But the church does that with a promise of confidentiality. And what the state, we were arguing, was trying to do was seize that confession that the church compelled, strip it of its confidentiality, and use it for state purposes when the state could not itself compel that speech. We called that a commandeering claim. Uh, it's not been recognized previously, but sort of the underlying pieces of it have been recognized. This idea that the state can't use the church to accomplish the state's own ends.
Okay, so where would that argument be housed in sort of constitutional jurisprudence? Where would you put that?
Well, we certainly put it in the First Amendment. I think we view it as sort of the combination of the two religion clauses. So in the same way that the Supreme Court has recognized what we'll talk about in a second, the church autonomy doctrine as being a function of both of the religion clauses. I think we would say that our commandeering claim was again a function of both clauses, that the state, it created an establishment issue because the state is seizing control in some way of a church sacrament, and yet it's changing the sacrament in a way that it affects its exercise by the participants. So it really runs afoul of both of the religion clauses of the First Amendment.
Yeah, it kind of reminds me of when President Jefferson was responding to the Danbury Baptists who had written him a letter saying, "Hey, hopefully we'll kind of basically continue to have religious liberty over here, right? It's all going to be okay." And he talked about his wall of separation. I think the razor wire was pointing at the government, not at the church. And certainly that seems to resonate. That idea that he was talking about in that letter resonates with the commandeering argument. So there's this thing called the church autonomy doctrine. You guys brought that as a claim, and now the FedSoc hosted a webinar on the church autonomy doctrine back in July 23rd, 2025. If it's a new doctrine to you, you're unfamiliar with the phrase church autonomy doctrine, you can go pull that webinar up. We're not going to rehash everything from there, but give us like the 60-second version, Matt, of what is this thing called the church autonomy doctrine, and like where does it come from?
Yeah, so dating back to the mid 1800s in a case called, I think, Watson v. Jones, the Supreme Court recognized that with regard to matters of internal church governance, the courts had no say, and that initial statement in Watson had been developed over the years in a case called Serbian Orthodox Church, and then more recently in the context of employing ministers. So Our Lady of Guadalupe, as one case more recently. And so the gist of it is that when it comes to matters of internal church governance, so things like church discipline or employment of ministers, that those type of things are governed by the church, and the state is absolutely prohibited from regulating them. And here, what we argued, was a matter of church governance, a matter of church discipline. Roman Catholic teaching is that the priest serves as, in part, the judge in the administration of the sacrament, and provides mercy to the participant as well on God's behalf. And so this governance activity has rules around it established by church doctrine. And what we were arguing was that what the state was trying to do was violate the church's autonomy by inserting itself into that governance function and rewriting the rules, so to speak, literally changing how it's administered by law. And so we argued that that violated the church autonomy doctrine. Again, a function of both both religion clauses of the First Amendment.
Yeah, and the statute kind of had a quirky thing about, that dealt with people that were both receiving confession but also supervising. The supervision component of that, of supervising others who would be potentially receiving confession, and obviously, you had a multitude of clients within a hierarchical structure, some of whom are those supervisors. So if you have this law, it's coming into effect in July, or was going to go into effect in July of this year. It was May 29th when you filed. You filed something else along the lines. You filed a preliminary injunction motion. Tell us about there was an argument. Tell us a little bit about the argument for the preliminary injunction motion. How did that go, and who all was a participant there?
Well, the oral argument was on a Monday in Tacoma, and we were prepping in a moot court on Friday when we got a set of questions from the court that the court wanted us to address at the hearing. And one of them was something like, and I'm paraphrasing, but only slightly. Plaintiffs argue that the law commandeers their religious practice. Isn't that correct? And so we felt pretty good about that. So we decided over the weekend, rather than wait until Monday to provide responses at the oral argument, we would write up responses. So the court had, I think, maybe 4 questions for both parties, and then 3 or 4 questions for us, and like 9 questions for the state. So we prepared written responses to the ones that were to jointly to both parties and to ours, and filed them on Sunday night. And the result of that was, when I got out to oral argument on Monday, since it was my motion, normally I, on behalf of the plaintiff, would go first, and the court said, I think I've got your position. Let's start with the state. So it was an unusual structure where most of the argument was by the party opposing. I got up and offered some brief comments in rebuttal, very brief, because the judge had signaled that he didn't want to hear a whole lot more. And when you appear to be winning, you should stop talking. And so I said very little. And we were optimistic, based on the judge's comments, that things were headed our way. But the state had focused most of its argument on standing, because we were bringing a pre-enforcement challenge, and they were arguing that it wasn't ripe and that we didn't have standing. And that's where they focused most of their discussion during the oral argument.
Now, something happened to the county prosecutors did not present during the preliminary injunction hearing. What happened to them?
Before we showed up on that Monday, we had an agreement with all the county prosecutors that they would stipulate to the entry of a preliminary injunction, and just let the state, specifically the governor and the attorney general, argue the case, and that they would live by whatever result came about with if a permanent injunction came about. And so we had literally every single one of the county prosecutors that already stipulated to a preliminary injunction, which the court entered before we even started.
Now, obviously I saw the questions that Judge Estudillo put forth. I'm always impressed by these district court judges that have these massive dockets of, that obviously that's a major metropolitan area, Seattle, Tacoma. But judges all over the country, these district court judges that have, huge, hundreds of criminal cases, tons of complex civil cases, and the amount of preparation and the types of questions that a lot of these judges will ask, I always find it very impressive at how much time they're willing to spend on a case on a topic that they're not going to see very often. I mean, I was impressed by his questions, the insight, just the study that he must have done on the free exercise clause, on the sacrament, on church autonomy. He was just really evidenced a lot of hard work. Is that, I mean, did that seem unusual to you? It seemed unusual to me, even given the fact that I've always been impressed with how well judges dial into this issue they see only occasionally.
Yeah, I mean, certainly you think about just the time crunch in a preliminary injunction motion, right? You're talking about bringing a case, briefing the merits of it very quickly. The whole point is we need emergency relief before the law takes effect on July 25th. So the judge had, I think after our reply brief was filed, had like maybe 10 days, roughly, maybe a little longer than that, to consider the papers, and clearly understood the issues, understood not only the facts, but had read the relevant cases, had sort of honed in on what the pressure points were and asked the insightful questions. So, as you said, it's always impressive when a judge can dive into a topic area where he or she doesn't regularly practice. I don't know how many, I don't we didn't find any other religious liberty cases that Judge Estudillo had before. And he hasn't been on the bench that long. I think he was appointed by President Biden. So it was a very quick turnaround, and he was very much on top of the issues.
Yeah, I mean, it was a different judge. It was the same courtroom as the origin story for Kennedy versus Bremerton, but definitely Judge Estudillo is really demonstrated that he's pulling all-nighters or something. He's working pretty hard to be able to prepare that well on a topic you're not going to see very often. So what happened after that? You got a ruling. How long did it take, and what did it say?
Well, we argued the case on Monday, and we were at a conference, a religious liberty conference. Hiram and I were together on Friday when we got a ruling, and the judge granted our preliminary request for a preliminary injunction, finding that we were likely to succeed on the merits. He found that the law was both not neutral and not generally applicable, so subject to strict scrutiny, and he ruled in our favor. He didn't reach the other arguments that we made. He didn't need to, and obviously that's as much as you'd like a judge to affirm every one of your arguments as genius. The judge, I think, took the proper approach of being deciding what he needed to decide and not more for purposes of the preliminary injunction. And so he ruled simply on that ground.
Well, so preliminary injunction's in place, which means the law obviously does not go into effect pending the case. Where do you think this case goes from here?
Well, we hope we win, as we always as we always do. We think that we're correct. The oldest known religious liberty case in the country's history, People v. Phillips from 1812, recognized protection for the sacrament of confession and its confidentiality. So we think we have more than 200 years of history on our side here, legal history, and so we're optimistic. But stay tuned.
Yeah, no, that's exactly right. Well, Marco is going to come on board now from FedSoc, and he's going to help us field some questions. So, Marco, do we have some questions in the queue? And if so, let's get those fired up.
Yeah, absolutely. And just a reminder to our audience, if you have questions, you can enter that in the Q&A function at the bottom of your Zoom window. Kevin Snyder asks, what argument did he use to get past ripeness for this pre-enforcement challenge?
Oh, that's great,
Yeah.
Matt. What'd you do for that?
Well, I mean, we had a number of things we were able to point to. So the first of all was the state was not willing to disclaim that they would enforce the law, and that is one of the primary factors under Ninth Circuit case law, the unwillingness to disclaim enforcement. We also had the fact that the law was specifically enacted to um, target the Roman Catholic Church, to target clergy in particular. But there was certainly references to the Roman Catholic Church in the legislative history. And so, part of our argument was the state claims they have a compelling interest. They passed this law to address clergy, and they won't say they won't enforce it. That sounds pretty ripe. We had also on top of that the fact that the state attorney general had been conducting an investigation in which he was trying to inquire into whether or not the church was reporting with regard to abuse cases. And so sort of all of that together, particularly in addition, including the ongoing state attorney general investigation and those other factors were sufficient for the court to conclude that the case was ripe.
Yeah, man, I got to imagine that if you're showing up to court and you're arguing, we have a compelling interest as to these particular plaintiffs right here, and also in another section of the brief, but their claims are not ripe, that somehow doesn't necessarily jive, and something to certainly got to give on that.
Yeah, and I'd also say, I mean, we had also each of the priests had also signed a sworn declaration saying that A, they take confession, and B, they won't comply with the law. What they couldn't say is sort of what the content of those confessions are, because that would itself violate the sacramental seal. But they said, we take confession, we won't follow the law. There's an ongoing investigation, you won't disclaim enforcement, and you pass the law because of us. And that together, the court found was sufficient, and it was clearly sufficient under Ninth Circuit case law to establish standing.
Right. All right, Marco, what else do we have?
Lee McGrath asks, have other denominations objected to the law, and points out that Eastern Orthodox, Lutherans, and Anglicans all have traditions of private confession.
Yeah, Matt,
Yes, yeah.
go ahead.
So the Orthodox Church of America has filed their own lawsuit, initially filed in the Eastern District of Washington and now transferred to the Western District. They are the only other tradition that I believe to date has filed a lawsuit. I am not aware of one by the Lutherans or any other churches.
And from what I understand, they have, Matt, tell me if I'm wrong, but they have an agreed preliminary injunction with the state as a result of the preliminary injunction that that you obtained
Correct.
prior to that.
Correct. So essentially, after we obtained a preliminary injunction, they reached an agreed preliminary injunction that was essentially identical to the one that we had reached with the county attorneys.
All right, Marco, what else we got?
Pete Overstreet asks, does the state intend to appeal, and if so, why?
Well, you would have to ask the state. They have not appealed, and what they intend to do, I don't know.
An anonymous attendee points out that Bob Ferguson is a very smart and capable lawyer and also a Catholic. And does him being a Catholic play into the argument for targetedness, and kind of what is your understanding of the interplay there?
I don't believe, I mean, we certainly reference the various statements that were made during the legislative process. I think one person in particular had said something like, one legislator had said something like, the church can change its rules if it needs to comply with the law. And we're like, well, they're not rules. It's doctrine, and no, you can't just change it. So I think that there were certainly, to be gracious, some degree of misunderstanding of what the church's teaching was and its centrality by those passing the laws, at least by some of those passing the laws.
And to kind of further address the question, um, do you think he was aware of the unconstitutionality of that law? And uh, very
Yeah,
capable lawyer.
yeah. I think what I would say is I don't assume the worst about state officials, that they act intentionally trying to violate the Constitution.
Yeah,
So
it's always
I
been my experience is that most state officials, they're trying to do what they think is right, what they think is the best thing, and that's one of the great things why we have our system of laws. We get to test those judgments.
Yep.
Marco, do we have? I think we have time for maybe a couple more questions. What do we have any more?
um, um, Pete Overstreet again just mentions that he's a Catholic and a prosecutor, and he was very fond of the commandeering argument. And if is there anything you want to say on that argument?
Other than that, I came up with it in the shower. No. Uh, it was really sort of trying to put together various pieces. Well, and to be in all seriousness, I mean, it seemed, there's something at a gut level wrong with this, right? The state can't compel people to speak, and yet they're trying to use the church's ability to compel people to speak. And at a gut level, initially, as we started thinking through this, there's something that seems wrong with this, but like, what is it? And it was a function of sort of thinking about, if you remember back that Supreme Court New York versus the United States, the commandeering case that said the United States can't commandeer the functions of a state to carry out the federal government's functions, or the federal government's policy. So that was part of the idea, sort of the why I called it commandeering. And then we were able to look at some law journal articles and about kind of historically what the Establishment Clause prohibited, and kind of we put those pieces together into this commandeering idea.
Yeah, well, it's a unique fact pattern, right? It's pretty rare for the government to to enact a law that's requiring religious or people of faith to do something on the government's behalf in a process that would not exist but for the faith's doctrine. So the faith creates somebody's faith or a group of people's faith creates a need to do a particular act, and then for the government to then say, okay, now we need you to do that act on our behalf. That's a unique fact pattern for this. Well, listen,
And I say on that, I think that's a very important point, right? Which is that the state, this speech only exists because of the religious faith, right? All the other evidence in the world that exists about this child abuse and neglect is still available to the prosecutors. The only thing that's unavailable is something that the religion creates and protects. And so it's not in any way impairing the ability of the state to investigate and prosecute this crime that would have existed absent this religious practice. And I think that's important to recognize that the state can still fully investigate these and should and prosecute them to protect children. And there's a way to do that while also protecting this religious practice.
Yeah, I think I'll wrap up with this. Look, it's religious liberty cases are always probably on their best footing when they're asking for narrow relief, and because of the narrowness of the relief being sought here, it wasn't a blanket exemption. It was just for the seal of confession. That itself typically lends itself towards the religious claimant prevailing. Well, listen, Matt, I want to thank you so much for coming and being part of the webinar, giving us an update on this important case. We'll keep track of that, see what's going on, and as things develop, have more updates for our listeners and the folks that are following along. So with that, Marco, I'll flip it back to you to close us out.
Well, I want to second the thanks for your time and expertise today, both of you. I would also like to thank the audience for joining us. We greatly appreciate your participation. For information on more upcoming events, please visit our website or all major social media platforms at FedSoc. On that note, we are adjourned. Thank you again.